This is your second presentation on the First Amendment. This is going to be covering the freedom of religion. It's going to go over the court cases that has put limits on the freedom of religion, and then it's also going to get into the controversy dealing with the issue of Christmas and religion. Again, the presentation is going to be given to you by Amanda Miller, and she will outline over the different sections of it. Make sure you're getting all your information filled out and your questions answered on your worksheets so that you have all this to be able to study for your test with.
Freedom of religion involves the Establishment Clause, which prohibits the establishment of religion by the Congress. It guarantees separation of church and state. Freedom of religion also includes the Free Exercise Clause. The government cannot prohibit the exercise of religion. Congress shall make no law prohibiting the free exercise of religion. This is also known as the Religious Freedom Clause. When the roles of government and religion are intertwined, the result is usually bloodshed or oppression. The difference between Establishment Clause and Free Exercise Clause is the Establishment Clause limits the government in their ability to establish religion, while the Free Exercise Clause protects the people's ability to practice their religion. Pierce v. Society of Sisters in 1925. Oregon wanted to require all to attend public schools. The Society of Sisters sued for going against their freedom of religion, and the Society of Sisters won. The 14th Amendment was applied to the First Amendment, freedom of religion. Ingle v. Vidal, 1962. In 1951, the New York State Board of Education approved a 22-word non-denominational prayer to recite in public schools every morning. The parents of 10 kids in the new Hyde Park schools objected the prayer. They filed in court seeking both of the prayer. A 6-to-1 vote in the court was in favor of the parents, and the court declared the prayer unconstitutional, because this goes against the Establishment Act. Schools are not allowed to promote daily classroom prayer because it is unconstitutional. Stone v. Graham in 1980. Stone and other parents in Kentucky challenged a state law that enforced a copy of the Ten Commandments in every classroom. Graham was the superintendent. A 5-to-2 in favor of Stone and the parents was ruled, and it furthered the separation of church and state by removing religion from schools even more, which took the Ten Commandments out of school entirely. Wallace v. Jaffrey in 1985. This involved the decision on the issue of silent school prayer. Alabama law required teachers set aside 1 minute each morning for meditation or voluntary prayer. Ishmael Jaffrey was a parent of 3 children and was against the maintaining or allowing the maintenance of regular religious prayer services or other forms of religious observations. He claims that 2 of his children had teachers who led their class and sang certain prayers. Jaffrey's child repeatedly asked for prayers to stop, however he was unsuccessful. Originally, the Southern Alabama Court allowed the practice and favored the defendants. However, the U.S. Supreme Court ruled 6-3 that Alabama law was unconstitutional. Once again, this pushes religion even further out of public schools. Santa Fe School v. Doe in 2000. It was a student-initiated prayer. Students were allowed to announce Christian prayers over the intercom at home football games. 2 sets of kids and their mothers, 1 Mormon and 1 Catholic, objected the practice and filed suit based off of the Establishment Act. They were anonymous and referred to as the Does. Court ruled these public prayers unconstitutional for on school property, at school-sponsored events, over the school public address system, by a speaker representing the student body, under the supervision of school faculty, and pursuant to a school policy that explicitly and implicitly encourages public prayer, is public speech, not private. Students cannot initiate religion in schools. For example, I could not pray over the whole cross-country team. U.S. v. O'Brien in 1968. criminal prohibition against burning a draft card did not violate the First Amendment rights or free speech. Paul O'Brien and 3 others burned their draft cards on the steps of the South Boston courthouse in front of a crowd. They did this in an attempt to persuade people to oppose the war. A 7-1 vote, 7 in favor of the U.S., saying this was unconstitutional, or O'Brien was in the wrong. It convicted under a federal law that made the destruction or mutilation of draft cards a crime. In 1972, the court used part of the O'Brien case to void a law that prohibited picketing outside public schools that wasn't related to a labor dispute. It imposes a selective restriction on expressive conduct. Texas versus Johnson in 1989 supported Gregory Lee Johnson's act of flag burning through freedom of speech in the First Amendment. The court considered whether or not it was a matter of speech since the act was nonverbal. The decision was that under the circumstances, Johnson's burning of the flag constituted expressive conduct, permitting him to invoke the First Amendment. Prior to this case, there were prohibitions on destroying the American flag. The court decided to indicate these laws in 48 of the 50 states. Since then, Congress has considered a flag desecration amendment multiple times. The Lemon Test in 1971 from Lemon versus Kurtzman. The Lemon Test used to determine when law has effect of establishing religion. In order for a law to satisfy the First Amendment, it must have some secular or non-religious purpose, must neither promote or inhibit the practice of religion, and must not foster an excessive government entanglement with religion. If a law violates any of these principles, then it is under the Establishment Clause. Christmas controversy, which involved the separation of church and state, or Christmas censorship. In 1870, President Grant made Christmas a national holiday. In 1998, Ohio lawyer Richard Ganulin sued the federal government. He tried to remove Christmas from the federal holidays. The government endorsement of Christianity, violation of the Establishment Clause, is what he tried to prove. The lawsuit was then dismissed in about 1999. Can the government display religious holiday symbols? Possibly. This looks at the context of display and decides whether or not there is a religious message. For example, a Christmas tree, Santa Claus, and teddy bears, they are acceptable. However, a nativity scene that reads "Glory to God in the highest," that breaks the Establishment Clause. Critics of the case call the court's approach the 3 reindeer rule. Symbols that in large quantities can justify an otherwise religious display, such as reindeer, Santa Claus, elves, and big trees. Some schools require that music programs play only holiday tunes. Nothing can be related to religion.
Okay, that completes the second presentation over the freedom of religion. Make sure you got down all those court cases and all the factual information from that to help you study for that on your test. And then we will continue in class going over some of the other material, or if you're doing this online, you will continue by getting the information from the other presentations then.